The Supreme Court Chamber of Extraordinary Control and Public Affairs was not unanimous. 3 judges dissented: Paweł Czubik, Tomasz Demendecki and Janusz Niczyporuk.
Sąd Najwyższy na podstawie sprawozdania z referendum
The Supreme Court decides on the validity of the referendum on the basis of the referendum report submitted by the State Election Commission and the basis of the opinion from the examination of election protests. This formula means that the protests are examined first, and only then is a resolution made on the validity of the referendum.
Protestów przybierają formę opinii, którymi Sąd Najwyższy, podejmując uchwałę,
Over 2,000 election protests were submitted to the Supreme Court. The chamber reported that 1,914 protest cases were left without further action because they did not meet formal requirements. The chairman of the State Election Commission, Judge Sylwester Marciniak, admitted that there would be no dispute if it were not the provision that the referendum is binding if the turnout is over 50%. Polish electoral law accepted that a quorum was needed for the referendum to be valid. Hence the political struggle between the main forces, one of which discouraged the collection of referendum card, as pointed out by OSCE Commission. The Prosecutor General Office drew attention to the anti-referendum propaganda that was omnipresent in the political media. For the most part, the complainants alleged that the polling station members asked voters questions about the issuing of the referendum card. They asked how many cards to issue or whether to issue a third card and the like. The referendum was held on 15 October at the same time as the parliamentary elections. The turnout was almost 41%, which means the plebiscite was not binding. Poles backed keeping the retirement age and the barrier on the border with Belarus. Voters also backed a ban on the sale of strategic state companies and rejected the forced resettlement of migrants.